Good morning. We're on the record in the Bremerton Municipal Court video and custody calendar.
Yo, give me one in there. Oh.
So first on the calendar I have is Adam Boyd, 502-00208 for an arraignment. 502-00204, 205, 206, and 207 will be arraignments on the motion to revoke filed by the city.
Oh yeah, there's a new charge, which is impossible.
So Mr. Boyd, you should have received a copy of the criminal complaint that's been filed against you, as well as a copy of the motion to revoke that also has been filed, and a copy of your rights. Do you have those documents?
Yes, I do.
Do you have any questions about your rights?
A few, but not right now. I'm not even trying to get into it right now.
Present on Zoom is Mr. Claridge from our Public Defender's Office, and he's going to assist with the arraignment process. The criminal complaint sets out one count, that is malicious mischief in the third degree, which is said to have occurred on about the first day of June 2022 in the city of Bremerton in the state of Washington, that you did knowingly and maliciously cause physical damage to the property of another in the amount not exceeding $750, contrary to the Bremerton Municipal Code.
Cool.
There's a maximum penalty of 364 days in jail and a maximum fine of $5,000. The court has read and reviewed the Bremerton Police Incident Investigative Report and does find that there's probable cause that a crime has been committed. On the motion to revoke, an amended motion to revoke was filed by the city prosecutor's office. It is dated June 1st, 2022. It sets out the following allegations: that there was failure to attend probation appointments, failure to comply with or file proof of chemical dependency evaluation, treatment, and or counseling, that you failed to remain abstinent, and that was for drugs on June 1st, 2022.
Got hired in the wrong way.
Positive for methamphetamine. Also, non-law abiding behavior, which was said to have occurred with the charges of the malicious mischief that we just went over.
I don't get to see your face either. I know it. Okay, we're not guilty now?
So Mr. Boyd, I need you to refrain from talking and make sure you're understanding what I'm going over as far as the arraignment charges, okay? So Mr. Reed, if you would further assist with the arraignment process at this time.
Of course, Your Honor. We'd request the court enter a plea of not guilty and issue denials for Mr. Boyd, as well as set dates for pretrial on this matter.
So the record will reflect not guilty plea on the criminal complaint of malicious mischief in the 3rd degree. The one count that's set out in the criminal complaint, as well as denials on the allegations set out in the amended complaint dated June 1st, 2022.
If I'm from Bailey, we did die. Yeah, you guys know you're involved with it because of all this huge investigation. 1, 2, 3. You just got brought into the judge. Don't look away. There you go. Just wanted to go right. Tried to tell you guys.
And the fact that you notice who's his underlying attorney.
Go. What's his face go? Yeah. Someone's trying to make me cover it up. Don't cover up the murder. They're so proud of themselves. They're gonna get it. Okay.
So in the matters that were set on for the motion to revoke, Mr. Bratt is the underlying attorney in those matters. Mr. Boyd, as far as your financial.
I'm broke, I'm homeless, I'm everything.
Thank you, Mr. Boyd. So nothing's changed as far as your sources of income.
Nope, nothing's changed except they got me on a charge. Yeah, is it cool? Let's go.
Okay, thank you.
Yeah. Hey, Reed, don't shake. Next time you book all my time, my brain come up with more shit.
Like a fever? Okay, I need to hit the mat.
Ms. Harvey, as the conditions of release.
Thank you, Your Honor. We would ask that Mr. Boyd be ordered not to have contact with Paul Wright, that he be ordered not to have alcohol, non-prescribed drugs, or marijuana. we are asking for bail in the new matter, the newly charged malicious mischief, in the amount of $5,000. I'd also ask for $1,000 bail in the motion to revoke matters total, because it appears he has not been, at least from the allegations today, he has not been following the court's orders as far as remaining abstinent,
What do you guys want?
and committing an alleged new law violation. Thank you, Honor. Thank you, Your Honor.
Mr. Claridge, as to conditions of release.
Thank you, Your Honor. We would request PR on this matter as well as the MTRs. This conduct was obviously stemming from a substance use addiction that's been plaguing Mr. Boyd. I do believe that that release would be a better fit for him to go seek treatment and hopefully get a shelter during this time. The offense is a malicious mischief, and over the past year, I understand the concerns of the city, but the disorderly conduct, malicious mischief, these are non-violent and typically substance use issues. I believe that custody is not the best place for Mr. Boyd to deal with the underlying cause of this, and I would request personal recognizance on these matters.
Thank you, Mr. Claridge. So, Mr. Boyd, Mr. Bratt was notified as to the hearing today. I know he is an attorney that you've worked with on your previous matters, and I need to assign counsel on your new charge, the malicious mischief. And go ahead.
There's a pot. This is the most confusing thing because I was given all this time and I had to do all my time by Miss Harvey. This charge is bogus because I honestly should have this released if I did all my stayed time and everything that's underneath that time. This charge needs to be talked to with me. The new charges that I'm under, I can't believe that there's a malicious mischief charge by Officer Hoyson because she picked me up on a warrant, is what she said. She had to pick me up on, but I believe in this, so.
I understand. I understand that there's some frustration, Mr. Boyd.
Okay, thank you.
And so I'm gonna reserve on appointing Mr. Brett until I know if he's available for the new.
I technically don't want him involved in my case because he didn't do anything in the first place.
Okay.
He did not come to me and talk to me about my stuff. I just pled guilty right there. I mean, I lied to Judge Doctor, but he did not come to see me.
Okay. So Mr. Boyd, the other option is the Lacrosse Murphy firm as far as representation.
I don't want that coming out of Judge Doctor's office either because they represented me last time and Philip or one of those guys, Noir, was disbarred because he messed up in my case. So I don't even want Judge Doctor. This is all messed up. You guys should not be you guys should not even be doing this with me right now. We should be in a Supreme Court. So not guilty, let's just do something. Reed, I'll see you soon, okay, bud? You don't understand what I know.
Mr. Boyd.
Yeah. Could I have a continuance or something? Thank you.
So as far as counsel, there appears to be a record noted in JABS as far as Mr. Boyd's conflict with the Lacrosse Murphy firm. Now it appears that there's a conflict with Mr. Bratt. Our other counsel is Eric McDonald. So Eric McDonald will be placed as counsel in all of these matters, and the record will reflect that. And the next court hearing for Mr. Boyd will be set for Friday, June 24th at 8 a.m. bail will be set in the amounts requested. And I will reserve any additional arguments as to bail if Mr. McDonald can talk to Mr. Boyd and meet with him and bring additional information back to the court.
Your Honor, was that 1K for each of the MTRs or 1K total for all motion to revoke?
So the bail in the new matter on the criminal complaint ending in 208, bill will be in the amount of $5,000. And for the motion to revoke on the 04, 05, 06, and 07 matters, bill will be a total of $1,000 for all the, yes. So in essence, the paperwork will reflect that bill is $250 each in the motion to revoke still. And I'll call up Daniel Tart next. And this is 513-41604.
Yes, ma'am.
On arraignment. Good morning. And 602 on a motion to revoke.
I just wanted to state ahead of time.
Mr. Tart?
Yes, sir.
Let's hold off on the commentary.
No, actually, I want to say something because last time y'all stopped me multiple times for saying something. And I'm not going to have it happen this time. Not trying to be a dick or nothing, but my paperwork was stolen from me this time. And I want y'all to fair warning to know that.
Thank you. So, Mr. Tart, I'm gonna just go over the arraignment documents with you, which is the criminal complaint, and then also a motion to revoke that's been filed by the prosecutor's office, okay? So if you can just bear with me, I'm gonna go over that. And then if there's information you want the court to know in addition to what you've already provided, then you'll have an opportunity to speak to conditions of release. So this morning, the charging document that you should have in front of you has one count of violation of a court order.
Yes, ma'am.
And that alleges on or about the 29th day of May, 2022, in the city of Bremerton, in the state of Washington, that you did with having knowledge of a Kitsap County District Court order previously ordering you that there was a protection order in place, a restraining order, a no contact order against Crystal and Mitchell, and that you did violate that restraining order.
No, they never called me around her. Incorrect.
Okay, I understand that you're denying that it happened, but this is what is alleged. Okay, so you don't have to agree with it, and I'm not asking you to agree with it. What I'm asking you to do is to just let me get through. Okay.
Sorry about
and this
that.
occurred. Thank you. And this is an occurrence that is contrary to the Bremerton Municipal Code as adopted by the RCW. This carries a maximum penalty of 364 days in jail and a maximum fine of $5,000. This allegation, the count one, the violation of a court order, has a special allegation that this occurred against an intimate partner. And the court has reviewed the Bremerton Police an incident report, an investigative report that is set out here, and finds that there's probable cause that there was a crime committed. The motion to revoke is dated May 31st, 2022, and it is an amended motion to revoke, and it has two allegations in it: non-criminal law behavior, and that has charges from the Kitsap District Court, which occurred in January of 2022, and then the current charges that I've just gone over with you in the criminal complaint, as well as failure to provide proof of evaluation and treatment, and that evaluation and or treatment is considered anger management. So those are the allegations that have been set out. Present on Zoom to assist with this process is Mr. Claridge. And the information as far as what your financial status, has anything changed since you were last appointed counsel?
No, nothing's changed. I'm still homeless and I still have no income.
Okay, thank you. So previously, in your underlying charge that is ending in the cause number 602, the LaCrosse Murphy firm represents you, and I would appoint them to represent you in these matters as well. And understanding that with the charge, the motion to revoke, that you're presumed to be and have not violated the conditions of your release or your JNS until the allegations are proved by a preponderance of the evidence, unless you admit to those allegations.
No,
So
I
Mr.
don't
Claridge
admit
is
to
gonna, okay, so Mr. Claridge is gonna assist with the remaining part of the arraignment at this time.
Okay.
Thank you, Your Honor. We'd ask to enter a denial and a not guilty plea for Mr. Tart at this time and set dates on the new matter for pretrial. Thank you.
Thank you.
Is there any
So
way
the record
today?
will reflect denial to the allegations set out in the amended complaint dated 5/31/2022. And the record will reflect a not guilty plea to the criminal complaint that's been filed in the matter ending in 604. I'll hear from the city as to conditions of release.
Thank you, Your Honor. In the new case ending in 04, the city is requesting $2,500 bail. I've listened to Mr. Tart this morning, his comments to the court, but an officer, Jeffrey Schaefer, observed the two parties together at a local agency on May 29th as the allegation. So contrary to what he's saying, the city believes
So can I ask you one thing? No.
there is sufficient facts.
Bus, they gonna throw me on the bus. If they saw me
Mr.
in the same, no. If they saw me in the same area, that is both a business. We are both allowed to go at that business together. Maybe she.
Mr. Tart, please do not talk on the record at this time. Please,
Bullshit,
please,
man. Y'all
please.
trying to hit me up for fuck ass charges I didn't fucking do. I ain't never been around that stupid ass bitch. Fucking white ass shit. Fuck ass motherfuckers. Charge me now. Motherfucker, they trying to fucking tell you the sounds around her. I never was around that bitch. Don't shut me, you stupid ass cunt.
Bye.
Fucking shut me.
Bye.
Ass bitch. Cause I showed you the bitch at the same time she comes up with this shit.
He's in crisis 3.
Shut up.
At the table.
Let's see this.
I can get that stuff.
Defense is going to reserve bail arguments on this matter.
Would the court mind muting us for a minute, please?
I'm asking for $5,000 bail. On
So Ms. Harvey, let it go right now. I think she's muted. Okay. So the conditions of release that were set under Mr. Tart's arrest will remain until we can finish up the arraignment process with him. Again, I've appointed the Lacrosse Murphy firm to represent him. We'll put this matter on again for Tuesday, June 14th at 8 a.m.
Your Honor, with all due respect, we might need to repeat that because we're trying to put our computer back together.
I will. I know you guys are trying to put things back together. So the next court date for Mr. Tart will be Tuesday, June 14th at 8 a.m. And the original bail set and bench warrants that were, the bench warrant that was issued, I believe, and my jabs went down, so.
You able to hear us?
We can hear you, yes. So, the 602 is about to die. Okay. Let me know when you're ready, Jill.
Your Honor, we're ready.
Okay. So for Mr. Tart, the next hearing date will be Tuesday, June 14th at 8 a.m. And the bill and the 602 matter had previously been set at $1,000. That will remain. As to the 604 matter, the court will also set bail. Currently, it is no bail. That will remain until the next hearing. So, Mr. Claridge, again, your firm is being appointed. If you're able to, once he's assigned, we're able to have Mr. Tart back in court, and then we can readdress bail at that time. Okay.
Of course, Your Honor. I'll see if we can't get him in before that 14th date.
Thank you. Mr. Robert Dearheim is next. And this is 513-29002 and 2003. Both of these matters are on for pretrial.
Thank you, Your Honor. I'm Mr. Dearheim's attorney. Mr. Dearheim has concluded his Superior Court matters, and so I intend to have these resolved pretty quickly now. I'll be meeting with him today, and I've just requested a short set calendar date for next week, where I'm hoping we can have this pretty close to resolution. Thank you, Your Honor.
Thank you. Is there any objections from the city? I believe I saw there was a resolution in Superior Court that took place on the end of May, just at his last court hearing date.
No objection, Your Honor.
Mr. Durham, I'm going to come see you today. Is there anything you need to put on the record now, or can it wait for?
They already sentenced me on a Superior Court.
Superior Court, yes. Yes, we saw that they sentenced you. So we're gonna have you back in court, Mr. Dearheim, next Thursday, June 9th at 8 a.m. And then that Mr. Parrish will continue to talk with the city prosecutor's office to be able to have a resolution in this matter and hope to get things resolved next Thursday, June 9th at 8 a.m. Okay?
Right.
Thank you. And we have Christopher Reed. This is 501-40203 and 501-40206. The 206 matter is at pretrial status. The matter ending in 203. A motion to revoke has been filed in that matter. That motion to revoke, Mr. Reed, has two allegations. One, a failure to file proof of evaluation and or treatment. And the other one is the non-law abiding behavior with charges from April 30th in the Bremerton Municipal Court. So on this is the time number 206 matter. He wasn't on my docket. So concerning the motion to revoke, you're presumed to have not violated the conditions of your JNS or suspended sentence until any allegation is proved by a preponderance of the evidence, or do you decide to admit the violation? You were previously appointed on your representative attorney on the 206 matter is Mr. McDonald. The court will appoint Mr. McDonald to represent. Represent you on the motion hearing as well. So Mr. Claridge is from our public defender's office, and he's going to further assist with the motion to revoke arraignment process today. Go ahead, Mr. Claridge.
Thank you, Your Honor. At this time, we'd request the court issue a denial and set dates for. Oh, sorry, Your Honor. What was that?
Go ahead.
And set
The
dates
record
for.
will reflect the denials and for fact finding and pre-trial. Thank you.
Thank you.
So the record will again reflect denials to the patients that have been set out in the motion to revoke, and a new pre-trial date as well as a fact-finding date will be set for the motion hearing. As to conditions of release, Ms. Harvey.
Thank you, Your Honor. Obviously, we're dealing with a case that has a prior pretrial, so there is an FTA within this matter, as well as some other failure to appear history for Mr. Reed. The city's not confident he will return to court of his own volition. We'd ask that bail remain in the amount of $5,000 in the 06 matter. We're also asking for $1,000 bail in the 03 matter. Thank you.
Mr. Claridge, as to conditions of release.
Thank you, Your Honor. I understand the city's concerns with the FTA history and the new alleged law violations. I would request a lower bail be set on this matter currently, though. I'd request 1,000 on the pre-existing one and 500 for the new MTRs that are incurred through this. These are nonviolent offenses. It seems to stem from the license issues that he's been having, as well as the issues with the driving. I just reiterate that, do not drive without a valid license, and just set a more nominal bail figure on these matters to reflect the nonviolent nature of the offenses. Thank you, Your Honor.
So as to conditions of release, Mr. Reed, you previously posted the $5,000 bail. That bill will be forfeited because of your failure to appear. The bail will remain as $10,000. And the matter ending in 604. And the motion to revoke hearing with the fact finding the matter ending in 6203. Bill will be set at $2,500. The next hearing for you in these matters will be set for Friday, June 17th at 8 a.m. That'll conclude your matter for today. Go ahead.
No.
You have a question, Mr. Reed?
No.
Go have a seat.
Okay, so we'll see you back in court on the 17th at 8 a.m. Next matter is Andrew Bae. And these are cost numbers 504-27811, 812, 813, 817, 818, and 819. The cost number 504-27819 and 504-27818 are pretrial matters. The 818, 812, and 813, and 817 are set as fact findings.
Thank you, Your Honor. Mr. Bae is one of my clients. I've just requested a short set over for next week. There have been some developments that I've done some investigation on my part that I'd like to share with him to potentially reprioritize our goals for negotiation. But either way, I think we'll be headed for a potentially speedy resolution on this one, and I wouldn't anticipate more than a couple more weeks of negotiation and meeting with Mr. Bae.
Any objections to a continuance?
No, Your Honor.
So these matters will be set on for, and Mr. Claridge, you're gone the weeks of the 13th and the 20th, correct?
I am, Your Honor. I've requested a date for next week on this matter. If we can't get to
I
a
understand that. I understand that. I understand what you requested. But I still need information on dates because next week, again, it's a limited calendar because it's judicial conference.
Of course, Your Honor.
So, Mr. Bae, Mr. Claridge is requesting a continuance on your behalf this morning to continue with negotiations and to be able to meet with you and provide you with additional information.
Okay.
So speedy trial in this matter runs on the 819 matter. The arraignment took place on May 19th. In both the 818 and 819 matters, the arraignment took place on May 19th. So, Mr. Claridge, the court will continue these matters to Friday, June 10th. That calendar will not be able to have a resolution on that day. You understand?
I hear you, Your Honor.
If you're looking to have a resolution, you would need to more than likely talk with your client about a speedy trial waiver to set it for after you return from your vacation, which would then be July. You're back the week of the 27th.
Yes, Your Honor. Last week of June, I'll be back.
So the calendar that we, either the 28th or the 29th would be a calendar where you would be able to resolve it.
I understand, Your Honor, and I'll discuss that option with him as well as potentially having an associate cover for a potential earlier change of plea if possible. Thank you.
So the courts are available the weeks that you're gone if you're able to get that paperwork in, but the 10th is a very limited calendar, and the time on that calendar is already pre-packed, and there's a pro temp covering that calendar. So we will.
I understand, Your Honor. I will. I'll tell him that we will not have a change of plea on at that time.
So and we don't have a regular pro temp. This will be a new pro temp. So okay. The matters for fact finding and a new pretrial date will be Friday, June 10th at 8 a.m. So, Mr. Bae, we'll have you back in court on Friday, June 10th at 8 a.m.
Thank you, Your Honor.
Thank you. And Troy Bishop. This is cause number 502-24508. And this matter is on for fact finding.
Yes, thank you, Your Honor. This is one of Jacob Murphy's clients. I'll be covering this matter for Mr. Murphy today.
Thank you, sir.
Mr. Murphy isn't present. Okay. And what is the anticipated resolution on this fact finding today? What is the request?
Thank you, Your Honor. We anticipate Mr. Bishop admitting to not meeting with probation and the failure to comply with CD treatment, the agreed recommendation negotiated with the prosecution on this matter is to impose 75 days and close out probation and treatment obligations.
So good morning, Mr. Bishop.
Well,
The motion to revoke was filed on March 18th, 2022. And that motion to revoke has two allegations in it: failure to meet with probation and miss probation appointments. And the other allegation is failure to comply with or file proof of evaluation and or treatment. And that's chemical dependency evaluation and complying with any treatment recommendations that would have come forward. And at this time, have you had enough time with your attorney to understand the rights that you would be given up by entering into an admission today?
yes, ma'am.
And you're prepared to go forward with resolution in this motion to revoke the fact finding today?
Yes, Your Honor.
So as to the allegations of failure to attend probation appointments and failure to comply with and file proof of treatment for chemical dependency, what say you today?
Sorry, I missed that. I couldn't hear. The light of the camera. No. Sorry, I couldn't hear.
We're having difficulties with the camera because it's pretty much broken.
Okay. What was that again?
So can you hear me?
Yeah, I can hear you now. Okay, better.
So as to the two allegations that are set out that I've gone over with you, the failure to attend probation appointments and the failure to comply with chemical dependency evaluation and treatment.
I failed it, yeah.
Do you admit those violations today?
Yes, ma'am.
Okay. So the court accepts your admissions that you're making them knowingly, intelligently, and voluntarily, and no one has made any threats of harm to you to enter into those admissions today.
Yes.
I'll hear from the city at this time.
Yes, Your Honor, this was an agreed upon resolution between Mr. Murphy and our office. Mr. Bishop, from what we know, is either unwilling or unable or uninterested in trying to complete the court-ordered obligations. This will be a back and forth battle for some time to come. And it just doesn't seem like that's going to be the best outcome for the court or for Mr. Bishop if he's already basically saying he's not going to comply with treatment. He may have more to add about that, about what the reasons why, but from the city's perspective, 75 days is fair, and basically saying, okay, well, if you're not going to do the treatment that seemed to be needed at some point, then, being in custody and away from society is really the only other option from the city's perspective. So we are asking for the 75 days. We are asking to close out his treatment obligations, and we are, I would leave it to the court as to whether to leave it open for any fines or I don't think there's there may be restitution. I haven't double checked on the restitution issue, Your Honor, but and we would ask that this time run consecutive to any other time he may be serving, which appears he's not serving for any other court. So that this would be a standalone sentence. Thank you.
So is it the city's recommendation that the time be imposed in this case be closed?
Yes, Your Honor.
I'll hear from Mr. Claridge as to sentencing.
Thank you, Your Honor. As Ms. Harvey has indicated, this was an agreed upon resolution negotiated between her and Mr. Murphy. I am unfamiliar with the facts of these cases, but I do understand that sometimes restorative or rehabilitative kind of treatment programs do not work for everyone. And in this case, it's unfortunate, but it is probably the best for Mr. Bishop to just finish out his time in custody and then use that time to sober up and try to reintegrate with society afterwards. Thank you, Your Honor.
Thank you. So, Mr. Bishop, before the court sentenced you, is there anything you would like to inform the courts of, or any statements you would like to make at this time?
I've been pretty much sober for 4 It's taken me a while to get to this point, but a couple of years myself. But, it's just a trigger for me to go to these groups like that. I gotta keep it simple, and it's a trigger for me. And I'm gonna do better this time.
Thank you, Mr. Bishop. So this sentence was entered into on January 13th of this year. It was a suspended sentence for 24 months. I was the presiding judge at that time when the Alford plea was entered. At that time, 45 days was imposed.
I say, I've already did 90 days straight time or 100 days straight time so far.
So the sentence was 45 days imposed, 30 days for electronic home monitoring. There was a failure to appear. You were back in custody on February 1st. And the 30 days electronic home monitoring were imposed to be served in custody. While this was a negotiated recommendation, it is a bit disturbing that it's the city's and defense's position on a matter that has 2 years jurisdiction to come up with this resolution. At such an early date in this matter. So the court has accepted the sentencing in this matter. To Tuesday, June 14th at 8 a.m. So, Mr. Bishop, I'll have you back in court for sentencing on June 14th at 8 a.m. The next matter is Tori Washington. This is cause number 501-08503, and this matter is on for pretrial.
Yes, Your Honor, and this is one of Mr. Stanley's clients. I'll be covering for him today. We're just asking for a set out on this matter. Mr. Washington still has pending DV felony matters that we're kind of waiting for the go-ahead from his attorney of a record on that matter before we can successfully negotiate ours.
So
And I don't believe we'll have a speedy issue as apologies,
No.
Your Honor.
This matter was set on for hearing on the 31st. On the out of custody calendar, on that date, we learned that Mr. Washington was in custody, so it was set over for this calendar. So on the 31st of May, the failure to appear is noted. I see that Mr. Stanley is asking for a continuance of this matter until June 29th at 8 a.m. Are there any objections from the city?
No, Your Honor.
So this matter, Mr. Washington, will be continued until June 29th at 8 a.m. We'll have you back in court then. And that'll conclude your matter for today. Mr. Washington, your next court hearing date will be June 29th at 8 a.m.
Thank you, ma'am.
Thank you. So Jill, on the refused matters, we have Joshua Wiley, 501-67805. You can try again tomorrow, and you can let Mr. Wiley know that if he doesn't appear, the courts will enter an order to make him come into court. Okay. Jess Tronson. Also an arraignment. We'll put him on for tomorrow. Well, for Tandy Mathis, we'll put that matter on. This matter is on for sentence compliance, so we'll put this matter on for her for Tuesday of next week at 8 a.m.
Thank you, Your Honor.
Thank you. So on our 9 a.m. calendar, we have Mr. Glisson on 513-46901. This matter was on for jail review on the, I believe, ignition interlock. That matter can be stricken unless we need to set a new hearing in that matter. Let's see. I do believe that we received the proof this matter in Jackson. This is a jail review. I said, Laurie Stackhouse. That's the last name. Maybe if that's how it's written on my docket. It was on the docket when I reviewed it last time. Mr. Glisson?
Morning.
Good morning. So in your matter for Mr. Laura Stackhouse, we
Yeah.
received the proof of what we needed for the DUI. So, and Mr. Stackhouse is I believe that, just let me verify this information. So, Mr. Glisson, the Bremerton Police provided the court with proof that the electronic home monitoring for the 180 days has been hooked up on, so he's serving that. We don't have any need for a future review hearing. All the other requirements have been met. So,
Okay.
I apologies that the clerks didn't notify you that we received that information. Okay.
No worries at all. Thank you very much, Your Honor. Have a great day.
Thank you. Also, the Dylan Grady matter.
Good morning, Your Honor.
Good morning. And also in this matter, we received the information in regards to the DUI ignition interlock install. We've already set the next hearing as June 22nd. So this matter again is resolved for today. We just need that proof. So that'll take care of your appearance today as well. We'll see you on June 22nd.
All right.
Thank you.
Thank you, Judge. Have a good day.
You too. We also have Laurie Moore, 513-15201. Is there Laurie Moore present? Can the person in the Zoom room identify yourself?
Hillary Albro.
And what matter are you here for?
I was arrested last night for a warrant out of Bremerton for a driving while license suspended in the third and a false or misleading statement to a police officer from 2018, I believe.
Your Honor, Attorney Julia Simmons on behalf of the defendant. She's present before court via Zoom, Your Honor. I have spoken to the prosecution on this case. I'm asking for the case.
Hold on, Attorney Simmons.
Thank you.
I have not called the matter. I asked for the person in the Zoom room to identify themselves. So just
I
hold on.
apologize, Your Honor. I was on the other phone. I thought you called the matter and I heard her speaking.
Just hold on. Just hold on. So again, I'm looking for Laurie Moore, 513-15201. Is there a Laurie Moore present? This matter was set for jury trial. Ms. Moore missed the readiness hearing. Mr. Claridge?
Oh,
Yes, sir.
Donna, I gotta call you back.
Ms. Attorney Simmons, you need to mute yourself until your matter is called. Any information, Mr. Claridge, on Ms. Moore?
No, Your Honor. I've been trying to get a hold of her and believed she would have been at this hearing. I would request a resummons on this. I have a couple numbers that I've been trying to reach her at, and she has been good at getting back to me up until just that a few days before the readiness hearing.
So, Ms. Harvey, again, there was a failure to appear at the readiness hearing, which was on the 27th of May. It is now 9:08.
Yes, Your Honor, the city is concerned that she hasn't apparently contacted her attorney or showed up for court on these last two hearings, or court dates. So I would ask for a warrant in the amount of $5,000.
So I'm reviewing the docket in this case, and it does look like there has been a previous failure to appear back in December. As well as last March on the 3rd, the 17th. So the court will issue a bench warrant in the amount of $5,000 for Ms. Moore and cause number 513-15201. The review of the record and failure to appear at readiness, as well as today is her trial call. And that is this is from 2019. So cause number 505-39806, Ms. Albro.
I believe that's my matter, Your Honor.
Ms. Simmons,
Yes, Your Honor.
hold on a second. This matter comes before the court on a book and release from a bench warrant that was outstanding. There was contact made with the court. Last in this matter on August 27th, 2019. At that time, there was the screening for the public defender, and LaCrosse and Murphy was appointed in this matter. So currently, the attorneys of record is LaCrosse and Murphy, which is our public defender firm. So Ms. Simmons, if you're appearing, have you filed a notice of appearance?
Your Honor, I have not filed a notice of appearance. I was told very early this morning, and I'm actually out of country, that this case was going on calendar today. I would like the opportunity to have a little bit more time after the arraignment to file the notice of appearance, but I do believe that we will be able to resolve this case on the next court date, Your Honor.
So Ms. Simmons, this is not an arraignment. She's already appeared on this matter. She's already been arraigned. She's already been assigned counsel. So you would need to file a notice of appearance as well as substitution of counsel, because her attorneys of record at this time.
I understand that, Your Honor. And like I said, it was late, very late notice.
So Ms. Moore, have you retained counsel? Ms. Albro, have you retained counsel?
I've asked Julia Simmons if she would help me with this case. I never even met with attorney or with Murphy and LaCrosse before.
Thank you.
Yeah.
So Ms. Albro was arrested on the warrant yesterday.
Yes, Your Honor.
She signed a promise to appear today. This matter is in pretrial status. So it can be set for an additional pretrial. Any objections from the city?
No, Your Honor.
The next available pretrial calendar is July 6th at 3:30 p.m.
Your Honor, can we come back on July 12th, Your Honor?
July 12th at 2:30 p.m.
Thank you, Your Honor.
So Ms. Simmons,
Yes, Your Honor.
the appropriate paperwork needs to be on the court docket and filed in the court file by close of business tomorrow.
Not a problem, Your Honor. Thank you.
Thank you.
Bye-bye.
Ms. Albro, your paperwork for your next hearing is available for pickup at the clerk's office. You'll sign for your next court date, and we'll see you back on July 12th at 2:30 p.m.
Thank you, Your Honor.
Thank you. don't believe there's any other matters from our 8 o'clock docket or our 9 a.m. trial call calendar. Except for our trial that's going out in 513-31001. So this will conclude our matters on the Zoom. Thank you, everyone.
Thank you.